Good morning, everyone. I am going to give you a very brief overview of the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. It's pretty straightforward. Next slide, please. Under what the Act does is it allows employees to bring sexual assault and sexual harassment claims that have already entered into pre-dispute arbitration agreements or pre-dispute class or collective action waiver. Some of you may already put those in place in the effort to avoid litigation and try to increase the speed of the process of resolving disputes. And what the Act allows is that the employee may elect that the agreement or waiver that they signed prior to the dispute not be valid or enforceable with respect to a case that they bring in court. It includes claims for sexual assault or sexual harassment. Next slide. So what the Act covers is a pre-dispute arbitration agreement, which is any agreement to arbitrate a dispute that has not arisen yet at the time the agreement was made. So all of the agreements that exist prior to the Act becoming effective are impacted by this Act, and obviously any agreements you enter subsequently. Same with the pre-dispute joint action waiver, which is an agreement to prohibit collective actions. Again, same thing. It would apply if the dispute has not arisen at the time the agreement was made. Sexual assault disputes include any non-consensual act or sexual contact as defined under applicable law, federal law, tribal law, or state law. Sexual harassment disputes is a dispute relating to conduct that's alleged to constitute sexual harassment under state or federal law or tribal law. Next slide. Employers may be able to sever unrelated claims and compel arbitration. Those would be non-sexual harassment claims or non-sexual assault claims. After the harassment or sexual assault claims arise, an employee can enter into an enforceable arbitration agreement after the fact. Employees who are asserting claims can also voluntarily elect to proceed with arbitration. Again, it's all up to the employee. And it's the courts, not the arbitrators, who will determine whether the Act applies and whether the agreement requiring arbitration for these types of cases is enforceable. And that is, it's up to the court to decide, even if your arbitration agreement delegates that determination to an arbitrator. Next slide. Steps to consider that the employer should consider is whether you revise your arbitration agreements to provide for how claims that are not sexual harassment or non-sexual assault claims will be handled. You can revise your agreement to exclude the arbitration agreement to exclude sexual assault or sexual harassment claims. So your wage claims, any other types of disputes that might arise would be arbitrable. You could include a provision in your arbitration agreement requiring that sexual assault or harassment claims be severed and stayed pending the completion of claims that are arbitrable, which would be the non-sexual harassment or non-sexual sexual assault claims. The one thing to consider, though, is what are the pros and cons associated and the costs associated with creating dual form litigation, meaning you'd be arbitrating the non-sexual harassment and non-sexual assault claims, and then also be in court for the claims concerning sexual assault and sexual harassment. There is a question under the Act as to whether, when a claim is brought, it references the word case, and whether the statute will be interpreted to include all claims, whether they're sexual assault or sexual harassment. And any of these revisions that I've suggested to be considered, it's an open question as to whether the court will accept them or not. Next slide.